Let's look at our parents' rights for USD 259. First of all, the Supreme Court of the United States in 2000 declared that the liberty interest of parents in care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by the court. In fact, this right of parents to direct the upbringing, education, and care of their children predates the court itself. This was brought on by Traxel versus Granville. The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations, as says Pierce versus Society of Sisters. The law's concept of the family rests on a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More important, historically, it is recognized that natural bonds of affection lead parents to act in the best interests of their children. Most children, even in adolescence, simply are not able to make sound judgments concerning many decisions, including their need for medical care or treatment. Parents can and must make those judgments, as said by Parham versus J.R. When we look at the rights of parents, we see parent participation, parents' rights in special education notice, prior written notice, parent consent, notice of IEP meetings, the rights for parents of gifted students, education advocates, and students who are 18. With parent participation, Congress mandates that parents be afforded the opportunity to be members for any decision making team of their child. This includes eligibility, initial evaluation, and reevaluation. And this also includes development of an IEP for the provision of FAPE. Schools must ensure parents have the opportunity to be members of the IEP team that makes decisions on the educational placement of these students. Parents also have a responsibility to participate and provide their input for their child's educational needs. Every child with an exceptionality is entitled to FAPE, and parents' rights are intended to ensure students receive this FAPE. Parents are to be provided notice of meetings, and parents need to ensure attendance at these meetings. To ensure parents have knowledge about their rights under the special education law, schools are required to provide a copy of the parents' rights and special education notice to the parents at least one time in a year upon a referral or parent request for initial evaluation. First, formal complaint or due process complaint filed in the school year. Upon a disciplinary removal that constitutes a change in placement. Upon parent request, or notice needs to be provided in the parent's native language. All of these things need to occur. When we look at prior written notice, one of the procedural safeguards afforded to parents is this prior written notice of certain proposed special education actions. This notice must be provided to parents within a reasonable amount of time before the date the school proposes to initiate or change identification, evaluation, educational placement of their child, or provision of special education and related services, which is considered FAPE, to this child. Prior written notice is also provided when the school refuses a parent's request to initiate or change identification, evaluation, or educational placement of their child, or to make a change to the provision of the special education and related services. This prior written notice is provided to the parent when the school proposes to make a change in services, placement, anything that is not substantial or that is substantial or material. However, parent consent is not required for changes such as the prior written notice provided to parents for each proposed special education action that must be contained with specific information. And this is a description of the action proposed or refused, an explanation of why the school proposes or refuses to take action, a description of each evaluation procedure, assessment, record, report that the school has used as a basis for proposed or refused actions, a description of the other options the agency or IEP team considered and why they were rejected, a description of any other factors that are relevant to the proposal or refusal, a statement the parents have parental rights under the law, sources for parents to contact to assist in understanding their rights under the law. Additionally, if the notice is to propose to conduct an initial evaluation or reevaluation, the notice has to describe an evaluation procedure. If we look at parent consent, federal and state statutes and regulations have specific requirements for requesting this parent consent. Consent is always to be informed consent. The prior written notice must accompany the request for consent for each proposed special education action, and the parent must agree in writing to this action for which his or her consent is sought. Parental consent, again, in determining that informed consent is obtained, the following has to be adhered to. The parent has been fully informed of all information, and it has to be in the native tongue of that parent. The parent understands and agrees in writing to the carrying out of the activity for which his or her consent is sought, and it describes the activity, lists the records, anything that will be released, and to whom. The parent understands the granting of this consent is voluntary and it can be revoked at any time. If a parent revokes this consent, the revocation is not retroactive, meaning that it does not negate an action that has occurred after the consent was given and before the consent was revoked. Parental consent is required for consent to conduct initial evaluation, to conduct a reevaluation, for initial provision of services on the IEP, to make a substantial change of placement, and that's more than 25% of the child's school day, to make a material change in services, 25% or more of um, any one service, to add a new service, to delete a service completely, for evaluation of services in private school, to excuse an IEP team member from the IEP team, especially from the meeting. And consent does not have to be written, it can be verbal. To invite an outside agency, consent, again, does not have to be written. And for use of Medicaid, does not have to be written for that consent. And for use of private insurance, and again, does not have to be written. Parental consent is not required for reviewing existing data as part of an initial evaluation or part of the re-evaluation. It is not required for administering a test or other evaluation that is administered to all children unless consent is required for of course, the parents of all the children that are being administered for this test. Any other proposed educational action where parental consent is not specifically required by special education statutes and regulations, and in these situations, only prior written notice to the parents of the action proposed or refused is required. Um, Electronic signatures, parents, other education decision makers may provide consent with electronic signatures under three conditions. The document identifies a particular person as the source of the consent. The document authenticates a particular person as the source of the consent, and the document indicates such person's approval. Parents do not respond, and when this happens, the school must take reasonable attempts to obtain consent from the parents for each special education action is required. These reasonable attempts are defined as at least two contacts by two different methods, and documentation of these attempts should be kept, including the detailed records of the telephone calls made, the attempted results, copies of written correspondence, um, if any, and of course, visits that are made to the home, place of employment, and of course, any responses that are made from the parents. As indicated previously, parent consent is required to conduct a reevaluation, make a material change in services, or substantial change in placement. However, parent consent is not required for these actions if the reasonable attempt time the parent within that time frame the parent does not respond, and the school has requested for consent, and the school can document that it has attempted and it was not gained because of the attempts that were made fatally. If parents revoke consent, of course, parent consent is voluntary. It can be revoked by the parents at any time. Revocation of consent has to be in writing. If a parent revokes consent for all existing special education related services, the LEA may meet with the parent to attempt to resolve this difficulty. If the parent cannot be convinced to continue the services, the LEA must honor the parent's revocation. However, the LEA must provide prior written notice a reasonable time before ceasing the provisions of the services, and the LEA may not attempt to override the parent's revocation of the consent through whether it's mediation, due process, etc. A parent's right to revoke consent to a particular service or placement is conditioned upon written certification by the IEP team that the particular service or placement is not needed to provide a free, appropriate public education. We are still mandated to provide FAPE. If the parent refuses to give consent or revokes that consent for one service or activity, the school cannot deny. When we look at the notice of an IEP meeting, the school must take steps to ensure that one or both parents are presented um, or attend this IEP meeting or otherwise afforded the opportunity to participate in this meeting. It is to be scheduled at a mutually agreed upon time and place, and the school has to provide notice of the IEP meeting to the parents for the initial IEP meeting and any of the subsequent IEP meetings. This notice has to be provided in writing at least 10 days prior to the meeting and inform the parents that their child is invited to attend. Um, and this written notice has to include the purpose, date, time, location, and the titles or positions of the people who are going to be attending on behalf of the school. The school may elect to identify the participants by name, but they have no obligation to do so. In addition, beginning not later than the first IEP to be in effect when the child turns 14 or younger, if determined appropriate by the IEP team, the notice must indicate a purpose for the meeting. Um, we have to look at post secondary goals, transition services, etc. Indicate the school will invite the student and identify any other agency that's going to be involved. And of course, that is with parent consent. Or if the student is 18, the student can consent to that as well. When we look at gifted students, the state statute also includes the category of this giftedness. In the state statute and regulations, the term exceptional children includes children who are gifted with disabilities. Special education services are not compulsory for children who are gifted. Therefore, if we have parents who are of gifted children, they can choose to accept whatever special education services are proposed by the IEP team, and they're required to provide the services specified in the IEP once the parent does give consent. Accordingly, parents of children with giftedness, and these are kids who do not also have a disability, they have the same rights as parents of children with disabilities, except for the following. The disciplinary protections for children in special education do not apply to students who are gifted. Preschool children under the age of 5 are not eligible for these gifted services. And students who are gifted do not have the same consideration for the LRE or the least restrictive environments as students with disabilities. Thank you.